Business method patents are a class of patents which disclose and claim new methods of doing business. This includes new types of e-commerce, insurance, banking and tax compliance, etc. Business method patents are a relatively new species of patent, and there have been several reviews investigating the appropriateness of patenting business methods. Nonetheless, they have become important assets for both independent inventors and the major corporations. Background. In general, inventions are eligible for patent protection if they pass the tests of patentability, patentable subject matter, novelty, inventive step or non-obviousness, and industrial applicability. A business method may be defined as a method of operating any aspect of an economic enterprise. History. France. On January 7, 1791, France passed a patent law that stated that any new discovery or invention, in all types of industry, is owned by its author. Inventors paid a fee depending upon the desired term of the patent, filed a description of the invention, and were granted a patent. There was no pre-examination. Validity was determined in courts. 14 out of 48 of the initial patents were for financial inventions. In June 1792, for example, a patent was issued to inventor F. P. Doucet for a type of tontine in combination with a lottery. These patents raised concerns and were banned and declared invalid in an amendment to the law passed in 1792. Britain. In Britain, a patent was issued in 1778 to John Knox for A.P. land for assurances on lives of persons from 10 to 80 years of age. At this time in British law, patents could only be issued for manufactured objects, not manufacturing processes. United States patents have been granted in the United States on methods for doing business since the U.S. patent system was established in 1790. The first financial patent was granted on March 19, 1799, to Jacob Perkins of Massachusetts for an invention for detecting counterfeit notes. All details of Mr. Perkins' invention, which presumably was a device or process in the printing art, were lost in the Great Patent Office fire of 1836. Its existence is only known from other sources. The first financial patent for which any detailed written description survives was to a printing method entitled "A Mode of Preventing Counterfeiting," granted to John Nias on April 28, 1815. The first 50 years of the U.S. Patent Office saw the granting of 41 financial patents in the arts of banknotes, bills of credit, bills of exchange, check blanks, detecting and preventing counterfeiting, coin counting, interest calculation tables, and lotteries. On the other hand, cases such as Hotel Security Checking Co. v. Lorraine Co. 160 F. 467, which held that a bookkeeping system to prevent embezzlement by waiters was unpatentable, were often read to imply business method exception, in which business methods are unpatentable. Another such case was Joseph E. Seagram and Sons v. Marzell 180 F2D26, in which the court held that a patent on blind testing whiskey blends for consumer preferences would be a serious restraint upon the advance of science and industry, and therefore should be refused. The change in practice in the 1990s. For many years, the USPTO took the position that methods of doing business were not patentable. With the emergence in the 1980s and 1990s of patent applications on Internet or computer-enabled methods of doing commerce, however, USPTO found that it was no longer practical to determine if a particular computer-implemented invention was a technological invention or a business invention. Consequently, they took the position that examiners would not have to determine if a claimed invention was a method of doing business or not. They would determine patentability based on the same statutory requirements as any other invention. The subsequent allowance of patents on computer-implemented methods for doing business was challenged in the 1998 State Street Bank v. Signature Financial Group The court affirmed the position of the USPTO and rejected the theory that a method of doing business was excluded subject matter. The court further confirmed this principle with AT&T Corp. v. XL Communications, Inc. The USPTO continued to require, however, that business method inventions must apply, involve, use or advance the technological arts in order to be patentable. This was based on an unpublished decision of the U.S. Board of Patent Appeals and Interferences, ex parte Bowman, 61 USPQ 2D 1665-1671. This requirement could be met by merely requiring that the invention be carried out on a computer. The reaction against business method patents after 2000. In October 2005, the USPTO's own administrative judges overturned this position in a majority decision of the board in ex parte Lundgren. Appeal No. 2003-2088. The board ruled that the technological arts requirement could not be sustained, as no such requirement existed in law. In light of ex parte Lundgren, the USPTO has issued interim guidelines for patent examiners to determine if a given claimed invention meets the statutory requirements of being the process, manufacture, composition of matter or machine. These guidelines assert that a process, including a process for doing business, must produce a concrete, useful and tangible result in order to be patentable. It does not matter if the process is within the traditional technological arts or not. A price for a financial product, for example, is considered to be a concrete, useful and tangible result. The USPTO has reasserted its position that literary works, compositions of music, compilations of data, legal documents, and forms of energy are not considered manufactures, and hence, by themselves, are not patentable. Nonetheless, the USPTO has requested comments from the public on this position. In 2006, Justice Kennedy of the U.S. Supreme Court cast aspersions on business method patents when he commented that some of them were of potential vagueness and suspect validity. This was expressed in a concurring opinion to the case of eBay Inc. v. Merce Exchange, LLC. There has been considerable speculation as to how this opinion might affect future business method patent litigation, particularly where a patent owner seeks an injunction to stop an infringer. In 2006, 3 justices dissented from the dismissal of certiorari as improvidently granted in Laboratory Corp. of Am. Holdings v. Metabolite Labs, Inc., arguing that State Street enunciated an erroneous legal test under which processes that the Supreme Court had held patent ineligible would be held patent eligible. The Bilski case in Bilski v. Capos, 561 U.S. 593, the Supreme Court held that the machine or transformation test is not the sole test for determining whether a claim comes within the process, subject matter of the Patent Act and is thus patent eligible. Rather than being an exclusive test for eligibility, the machine or transformation test is a useful and important clue, an investigative tool, for determining whether some claimed inventions are processes under 101. With respect to the facts of the case before it, the Supreme Court affirmed the Federal Circuit's en banc rejection of an application for a patent on a method of stabilizing cost inputs in the energy industry by hedging price rises against decreases. The court held that the investment strategy set forth in the application was an abstract idea, making it ineligible under that exception to the general subject matter areas listed in the Patent Act. The Supreme Court's decision in Bilski v. Capos affirmed but sharply qualified the Federal Circuit's 2008 en banc decision in re Bilski. The decision announced a machine or transformation test of patent eligibility that, if it had been accepted as the exclusive for process patents, would have made ineligible many business method patents granted in the last decade. Although the Supreme Court rejected its exclusive use, the test is still important as a useful and important clue for determining patent eligibility of claimed process inventions. Under this test, processes involving transformation of abstract financial data, such as that claimed in machine format in State Street, are probably patent ineligible. Second, processes that do not make patent-eligible transformations are patent-eligible only if they are claimed to be carried out with a particular machine. It appears that a programmed general-purpose digital computer is not a particular machine. For this purpose, it is unclear from Bilski whether a particular machine must be novel and non-obvious, and specially adapted for carrying out the new process. The Supreme Court's decision in Parker v. Fluke seems to call for that, but the Bilski court did not choose to opine on this point at that time. The majority opinion in re Bilski refused to hold business methods categorically ineligible on any ground. Judge Mayer's dissent, however, seconded by Judges Dykes and Lynn's concurring opinion, insisted that the U.S. patent system is limited to technology and therefore it excludes trade and business expedients. Judge Mayer equated the U.S. Constitution's limitation of patent grants to the useful arts, to a limitation to technology, relying on case law stating that technology is the modern equivalent of useful arts. In November 2007, the United States Internal Revenue Service proposed rules that would require tax filers who paid a license fee for a tax patent to declare that to the IRS. The Alice case several years later, in Alice v. CLS Bank, the Supreme Court readdressed the patent eligibility of a business method. It held patent ineligible a method of securing intermediated settlement, a form of electronic escrow. In invalidating Alice's patent, the court announced a two-step test based on the court's earlier decisions in Mayo v. Prometheus and Funk Brothers, Seed Co. v. Kalo Inoculant Co. This test first determines whether the claimed invention is directed to an abstract idea, law of nature, mathematical formula, or similar abstraction. If it is, the court is to proceed to the second step, determining whether the way the claimed invention implements the abstraction contains an inventive concept, as contrasted with being routine and conventional. Under the Alice test, the claimed invention is patent eligible only if it contains an inventive concept. Jurisdictions. Whether a business method is regarded as patentable subject matter depends on the legal jurisdiction. The World Trade Organization's Agreement on Trade-Related Aspects of Intellectual Property Rights does not specifically address business method patents. Australia. There is no general prohibition on the patentability of business methods in Australia. Their patentability is determined by applying the test used to determine the patentability of any type of invention. However, in the decision of Grant v. Commissioner of Patents, 2006, FCA/FC 120, at paragraph 47, the full court of the Federal Court of Australia held that a business method will only be patentable if it has a physical aspect, being a concrete, tangible, physical, or observable effect or phenomenon. Accordingly, pure business methods, being those that do not have a physical aspect, are not patentable in Australia. It has been suggested that Grant v. Commissioner of Patents was wrongly decided because the court failed to properly apply the existing law as set out in the decision of the High Court of Australia in National Research Development Corporation v. Commissioner of Patents 102 CLR 252, and that the court should not have imposed a physical aspect requirement. Canada. A business method must be more than an abstract idea or theorem, otherwise it is not patentable in Canada. In order to be patentable, the business method must have a practical application. However, a business method that is an abstract idea does not become patentable merely because it has a practical application. For example, a particular business method that is an abstract idea does not become patentable merely because it is programmed into a computer as an algorithm. For a business method to be patentable, the algorithm cannot be the whole invention, but only one aspect of a novel combination. See Amazon.com, Inc. v. The Attorney General of Canada, 2011 FCA 328, November 24, 2011 Brazil. According to Brazilian Patent Law 9279, commercial, accounting, financial, educational, advertising, raffling, and inspection schemes, plans, principles or methods, are not considered to be inventions or utility models. European Patent Convention. Under the European Patent Convention, schemes, rules and methods for doing business are not regarded as being inventions and are not patentable. To the extent that a European patent application or European patent relates to such subject matter or activities as such. But if a new method solves a technical, rather than a purely administrative problem, then it may indeed be patentable. India per Chapter 2, Section 3, part of the Indian Patent Act, business methods are not patentable per se. However, they are patentable if a new method solves a technical problem and an apparatus system is involved. Japan. In Japan, business methods are well recognized and accepted as patentable subject matter. The legal standard used to assess whether a business method is patentable requires that inventions be a highly advanced creation of technical ideas, by which a law of nature is utilized. Patents are not issued solely for business methods. The business method must contain a technical aspect that is both tangible and real. However, this requirement may be satisfied simply by specifying that the method is implemented using a computer. United States. Current U.S. case law. Alice Corp. v. CLS Bank International requires that in order for a business method to be patentable, it must be significantly more than simply implementing a well-known business process on a computer. The immediate response of the USPTO to this decision as of July 2014 has been to essentially stop allowing business method patents. The key issue is that examiners do not yet have clear guidance as to what is allowable under the Alice decision. Classification. In the 8th edition of the International Patent Classification, which entered into force on January 1, 2006, a special subclass has been created for business methods. GO6Q. In the previous editions, business methods were classified in GO6F 17/60. This is purely a classification matter and will not change the patent laws. However, U.S. patents describing methods of doing business that involve the use of a computer are classified in Class 705. Class 705 includes subcategories for industries such as healthcare, insurance, electronic shopping, inventory management, accounting, and finance. To inventor F.P. Doucet for a type of tontine in combination with a lottery. These patents raised concerns and were banned and declared invalid in an amendment to the law passed in 1792. Britain. In Britain, a patent was issued in 1778 to John Knox for A.P. land for assurances on lives of persons from 10 to 80 years of age. At this time in British law, patents could only be issued for operations. Background. In general, inventions are eligible for patent protection if they pass the tests of patentability, patentable subject matter, novelty, inventive step or non-obviousness, and industrial applicability. A business method may be defined as a method of operating any aspect of an economic enterprise. History. France. On January 7, 1791, France passed a patent law that stated that any new discovery or invention, in all types of industry, is owned by its author. Inventors paid a fee depending upon the desired term of the patent, filed a description of the invention and were granted a patent. There was no pre-examination. Validity was determined in courts. 14 out of 48 of the initial patents were for financial inventions. In June 1792, for example, a patent was issued to business method. Patents are a class of patents which disclose and claim new methods of doing business. This includes new types of e-commerce, insurance, banking and tax compliance, etc. Business method patents are a relatively new species of patent, and there have been several reviews investigating the appropriateness of patenting business methods. Nonetheless, they have become important assets for both independent inventors and the major manufactured objects, not manufacturing processes. United States patents have been granted in the United States on methods for doing business since the U.S. patent system was established in 1790. The first financial patent was granted on March 19, 1799, to Jacob Perkins of Massachusetts for an invention for detecting counterfeit notes. All details of Mr. Perkins' invention, which presumably was a